Good day, everyone. My name is Scott Reich, and this is Crime Talk. Yes, this is the weekly recap, a recap of all the top stories conveniently located in one location right here. Now, feel free to go watch all of these shows throughout the week, but here are the top stories. Thanks for watching. I hope you enjoy it. All right, next. A judge should have known better. He made every wrong decision, okay? Now, an Orange County judge out there in California was charged with murder in the shooting death of his 68-year-old wife at their Anaheim Hills home. Now, prosecutors announced last Friday that Jeffrey Ferguson was charged with one felony count of murder and one felony enhancement of personal use of a firearm and one felony enhancement of a discharge of a firearm causing great bodily injury and death. Now, Judge Ferguson faces a maximum sentence of 40 years to life in prison if he's convicted on all counts. And so, as things allegedly took place back on August 3rd, police responded about 8 p.m. to the judge's home following a report of a shooting. Officers found Cheryl Ferguson suffering from at least one gunshot wound inside the home there, and she was shot in the chest. She died at the scene. The couple's adult son called 911 to report the shooting, and a court filing from the prosecutor says that Ferguson texted his court clerk and bailiff minutes after the killing saying, quote, "I just lost it. I just shot my wife. I won't be in tomorrow. I'll be in custody. Sorry." Not good, Judge. You know better. That's a statement against interest. And he said he just lost it, apparently, during this argument. What's interesting, though, is guess what? The judge, he's been released. So, needless to say, the judge was arrested at the location at the near his house, and he posted bond and was released from custody the following day. Oh, and one final text. He said, "I can't believe I did this." Not good. Well, the good judge's arraignment is set for tomorrow, and as I said, they sought a non-monetary bail, including that the judge be required to surrender his passport. Can you imagine if you shot your wife in the chest and you just happen to not be a judge, if you're going to have a non-monetary bail? Go figure. What can you say, ladies and gentlemen? It's almost like there's a two-tier justice system, isn't it? Just saying, you make up your own minds. Just let me know what you think. Yes, let's call it Brian Kohberger. He wants his indictment thrown out, or in the alternative, at least give him a preliminary hearing. Now, for those of you that may not recall, Brian Kohberger says the grand jury that indicted him was flawed. That's the argument being made by his attorneys. And like I said, Brian Kohberger has been indicted for the deaths of 4 college students there in Moscow, Idaho last year. And he's entered pleas of not guilty. Now, his attorneys are doing their job, and they're challenging everything they can do to represent him, to do it both legally and ethically. That's their job, and he is facing the death penalty, so they're going to be a little more aggressive, to say the least. Well, today we're going to talk about the challenge to the grand jury indictment that they're making. Now, before ever reviewing the grand jury materials to determine if there was an actual violation of the Idaho Grand Jury Selection and Service Act, Brian Kohberger, through his attorneys, filed a motion to stay the case so they could actually look at the transcripts to determine if there was, in fact, a violation, even though they filed a motion saying there was a violation before they had actually looked at anything. I know. Think about that. Well, the judge said you hadn't made a showing yet, but I'm going to give you basically 37 days in which to come up with something, and they have. But it was filed under seal, so we don't have it. But what wasn't filed under seal was the prosecutor's response. And, well, let's take a look at it. The prosecutors argue that this motion was done not with any good faith at all, but was simply done to grind this litigation to a halt. Now remember, the speedy trial clock is ticking, and when the prosecutor is working on motions responding that could potentially be deemed frivolous, they're not working on the preparation of their case. So, like I said, the court granted that partial stay to allow the defense to come up with stuff, and this is what they came up with. Well, first, they're saying the jury is biased because somebody made some statements, and by statements made by the court. Now, we don't know what those comments exactly were, but let's face it, if somebody made some statements that were prejudicial to Brian Kohberger, they wouldn't have been on the grand jury. And if they made statements during the questioning of witnesses, that is not in and of itself anything that's going to get a grand jury thrown out. Now, I don't know what the judge said either, but I'm assuming the judge knew what boundaries of which he could say and couldn't say about the case. Probably something to the effect that it was high profile, things of that nature. Seems pretty unlikely the court's going to throw out the grand jury indictment because of that. Second, the defense alleges that the grand jury should have come from a separate list of jurors exclusively for grand jurors. And they cited a statute saying that, well, you should have a list for petite jurors, people that show up for jury duty, or grand jurors. But the statute actually says that the list can be made up of either grand jurors or grand jury. It's an or, not mutually exclusive. So that argument should fail as well. Third, they want the believe that there was a clerical error. There was some sort of exclusion of some information on the questionnaire that must invalidate the entire grand jury process. Probably a formality that a case number or something got cut off when making copies or something to that effect. Once again, don't think that's going to be enough to get the case thrown out. And then finally, someone checked the box that said they didn't speak English. Now, it is a requirement to be able to speak English to serve on a jury, whether a grand jury or a petite jury, the ones you show up for jury duty. You have to be able to speak English because that's how the evidence is presented. Well, you also have to presume that if they couldn't speak English and it was checked, they wouldn't have been permitted to be on the grand jury. So unless there was something there, I just don't see it. In reality, this is a weak argument that the defense is making, and I believe that it should be and will be denied. And we're making that obviously without the defense motion or the affidavit that they filed in this particular case. Now remember, a trial date is scheduled for October 2nd, although a lot of people anticipate that a delay will be likely here shortly. I don't know. I kind of like the aggressive tactic of the defense counsel in this case, saying, hey, you charged it. Let's go do this thing. We know they have a DNA expert. Let's litigate this stuff and let's do it. There's supposed to be a hearing on the 18th, which is Friday. We'll let you know what happens. Now, just remember, as a defense attorney, I get what they're trying to do. The defense attorneys for Brian Kohberger are trying to create an appellate record down the road. Although I think this issue is somewhat weak, they're making the record. They'd probably be better focusing on actually defending their case. As you may recall, they got to explain away that pesky little fact that their client's DNA is on that knife sheath on the K-bar sheath that was found underneath some of the victims. I think you need to come up, maybe spend a little more time on that. But hey, that's just me. I get it. They're doing their job. Alec Baldwin may still be charged in the Rust shooting that claimed the life of cinematographer Helena Hutchins. Well, there's new information. This is just a new forensic report concluded that the trigger was sufficiently pulled. Where have we already concluded that? Yes, I remember doing a live show where we talked about it, and I brought in an antique firearm very similar to the one at issue in Mr. Baldwin's case, and I demonstrated that it would be completely impossible for that gun to go off without somebody pulling the trigger. Anyway, criminal charges against Mr. Baldwin were obviously dropped, and the movie actually finished filming earlier this year. Now, Baldwin, who repeatedly denied pulling the trigger, may be called back into court over the killing. The firearms report that's been released in the co-defendant's case states, quote, the trigger had to be pulled or depressed sufficiently to release the fully cocked or retracted hammer of the evidence revolver. There it is, ladies and gentlemen. It did not just go off by itself. This fatal incident was the consequence of the hammer being manually retracted to its fully rearward and cocked position, followed at some point by the pull or the rearward depression of the trigger, according to the firearms expert, a guy by the name of Lucian Haig. And Mr. Haig, who the state attorney hired in the case against Hannah Gutierrez Reed. She was the armorer and the co-defendant of Mr. Baldwin at one point. Now, for those who don't recall, back in October of 2021, Alec Baldwin was holding the prop Colt .45 revolver that, according to him, and unbeknownst to him, contained live ammunition when it just went off and the bullet struck Hutchins and the film's director, Joel Souza. Now, after the shooting, the Santa Fe District Attorney's Office charged Baldwin, who also served as the film's producer, with 2 counts of involuntary manslaughter. Then in April, the charges were dismissed without prejudice because the statute of limitations had not run. And though the prosecutors noted that Baldwin could still face charges pending an investigation into the operation of the gun. So after Baldwin's attorney announced the decision, the special prosecutors said the decision does not absolve Mr. Baldwin of criminal culpability and that charges may still be refiled. Now, the gun and a broken sear have been sent to the state's independent expert for further testing, is what the prosecutor said at the time, and the charges against Mr. Baldwin were dismissed because of the possible malfunction of the gun that significantly could affect the causation with regards to Baldwin, not with regard to Gutierrez, wrote the prosecutors at that time. So if it is determined that the gun did not malfunction, charges against Mr. Baldwin will proceed, the prosecutor noted. And the prosecution's new report in the case against Gutierrez-Reed stated the gun found to function properly in accordance with the operational design of the original Colt 1873 single-action revolver. Although the full cock step on the hammer had been severely damaged, the top of the trigger's sear was broken off and the bolt was also broken because of on-the-set incident. There were no indications of modifications to the gun. And the August 22 forensic report from the FBI concluded essentially the same thing, that Baldwin would have had to have pulled the trigger. So I guess we'll see if the prosecutor's coming for Mr. Baldwin. That gun just didn't go off. There are some guns that have a history, a repeated propensity of going off. I'm not going to mention names because, we don't want to get in trouble or sued, but there's been a lot of litigation around a particular firearm. So, but this old Colt antique isn't one of them. Lori Vallow's on the road again. Governor Katie Hobbs, the governor of Arizona, has signed a request for a governor's warrant to bring Lori Vallow to the great state of Arizona and prosecute her. Now, obviously, Vallow was sentenced last month to life in prison in Idaho for her role in the deaths of her 2 youngest children, as well as her new husband number 5. That's right, his then wife, Tammy Daybell. So with the Idaho case complete, that gives the green light to the Maricopa County Attorney's Office to go ahead and prosecute Vallow on the 2 counts of conspiracy to commit murder, where she's been charged there in Arizona. So the Maricopa County grand jury indicted Vallow back in 2021 on the charge of conspiring to kill her 4th husband, Charles Vallow. And police say that Vallow, her brother, Alex Cox, shot and killed Charles Vallow on July 11th, 2019 in Chandler, Arizona. A second Vallow indictment came down in May of this year, charged Vallow with conspiring to murder Brendan Boudreau. And I'm sure I mispronounced the name, so I get it, but that's the way I'm pronouncing it, okay? Anyway, that's her niece's, that's Vallow's niece's ex-husband. And police allege that Alex Cox, Lori Vallow's brother, shot at Boudreau in Gilbert, Arizona on October 2nd, 2019, but he missed. Now, obviously, Alex Cox was never charged because he's dead. He died later that year, according to authorities, of natural causes. All right, I say let the circus begin. Let's get Lori Vallow to Arizona, and let's get some good attorneys. So we have good lawyering going on, not this limp noodle stuff that we had. Now, don't get me wrong. I don't think Lori Vallow was innocent, but who doesn't like a good trial? Come on. Anyway, on to the next new case. Brian Kohberger. That's right. Brian Kohberger's back in court literally as we film this for yet another pretrial hearing. in regards, obviously, to the killing of 4 college students there in Moscow, Idaho. Now, the judge is set to consider 2 motions from the defense and 4 from the state in the pretrial hearing for Mr. Kohberger. Those motions will determine whether a trial will be delayed. Trial is currently set for October 2nd. The hearing is not streamed, though a judge ruled that the victims' families and Mr. Kohberger's family could watch remotely if they could not appear in person. Now, there's still the defense motion to dismiss the indictment on grounds of error in the grand jury instructions and the procedures. That'll be heard. That'll be denied. Kohberger's defense team has said that Mr. Kohberger was out driving. The prosecution wants more specificity as to where he was driving. And probably the most important issue is the defense is asking for the 3 other DNA profiles that were apparently developed. The prosecutor is saying, no, you're not getting anything because it doesn't exist. But they say they'll go back and double check. The defense is also saying that the way that the prosecution went about obtaining the genealogical DNA that ultimately led to Brian Kohberger should not be allowed in. Hopefully we will have some news, but as of right now, the court has not ruled on those, at least as far as we can find out.